Hi, I'm Rodney Peyton, and in this episode of Beyond the Gavel, I'm pleased to be joined by Michaela Guthrie. She's recently minted partner at Balfour+Manson and one of Scotland's leading claimant solicitors in clinical negligence. She's accredited by both the Law Society of Scotland and the APIL, and she brings courtroom experience that ranges from the Supreme Court's decision in Montgomery, consent decision, to high-stakes fatal accident injuries. So over the next 20 minutes, we'll examine why consent remains the fault line in patient autonomy, how small firms can triage complex cases without drowning in the costs, and probably the practical examination hallmarks of a claim that should proceed versus one that should pause. So expect clear strategies, candid reflections from the front line, and, as in all Beyond the Gavel, insights you can apply to your very next client intake. So Michaela, welcome to Beyond the Gavel.
Thank you. It's great to be here. Thanks very much.
It's lovely to have you. It really is. Michaela, give us a little bit about your background. I mean, how did you get to where you are today?
So I'd always been interested in going into the legal profession, probably from quite an early age. I have been trying to think back to when it all began, but I think I've always had quite a strong sense of justice and injustice, which did lead to me getting into lots of scrapes and things like that at school, sticking up for people. And then obviously as I went through my school journey, I realized I quite enjoyed persuasive writing and trying to, express myself and persuade other people to my way of thinking using words and, whether it was spoken or written word. And then as I got older and started to think about choices for study, law seemed like quite a natural path for me. And litigation in particular was of interest to me from, I think, right from the start. As soon as I started thinking about law, it was litigation was the path that I wanted to take.
Right. And then you took on, med neg type cases. How did that start? Did you go straight in there or did you look around before you began?
No, so I've always been at Balfour+Manson, so I'm really lucky to have spent my whole career at such a brilliant firm. But when I first started out, I was in property, and I worked with some absolutely brilliant people in the property team. But I think I learned quite quickly that property was not my strong suit, and I think my supervisor at the time would probably agree with that. And I then moved into employment law, and then after that, the last two seats of my traineeship ended up being in the medical negligence and personal injury team, and I had studied Delict, as it's known, up in Scotland. I had studied Delict at university and I'd done it at honours level. I'd done an elective on the diploma. So I knew that it was an area that I was quite interested in. And I've always been quite interested in medicine as well. And for a very brief spell as a teenager, I thought perhaps I could be a doctor, but anyone who knows me will tell you how squeamish I am. So it was never really a starter. So I've been really lucky that I can combine, my interest in medicine plus litigation and the law. And it's a really fascinating area of legal practice. It's so varied. No case is the same. I know it sounds like a bit of a cliche, but it's completely true that no case and no client is ever the same in medical negligence. And you might have an area that you're really interested in. So I'm very interested in obstetric claims, whether it's claims for children or for women that have been injured during childbirth. And even within that very niche area, there's so much variety. And, women and children can be affected in so many different ways through childbirth being handled wrongly. So it's just such a fascinating area. And I'm really lucky and privileged to be able to help people at really difficult times in their life. So it's a really rewarding and interesting area of practice.
Yeah, it's that intellectual curiosity which you've got to keep going, and the understanding that you don't know what you don't know. There are a number of people that think, well, I've seen one of those before, so it must be the same. But I think you clearly pointed out they're not always the same, and you can make an awful mistake if you think you know it and you go through. I have a lot of experience, and I have to really look carefully and consider and reflect on what I'm going to say. I can't make a command decision and just say, well, it is. It's one of them. There are a few that you run through, but the majority you've got to really think about. So tell me, one of the big things that Balfour+Manson yourself got involved in was this Montgomery case. Can you give us just a brief overview of how that came about and what it meant to you?
So obviously training at Balfour+Manson, which is the firm that, that brought Montgomery all the way to the Supreme Court. And really persevered and supported Nadine through the case and got it to the Supreme Court. Obviously, it slightly preceded my time as a litigation lawyer, but it's something that's always been in the background and always been hugely aware of it. And obviously, the impact that it had on both the medical profession and the legal profession is huge. And it's a great case to, for as a legacy for our firm, it's absolutely brilliant. And the change that it brought to medical practice can't be understated. It was, a seismic change, I think, and meant a huge amount to, patient rights, patient autonomy, and kind of trying to end the medical paternalism that a lot of people have unfortunately experienced possibly over the centuries, definitely over the decades.
Very true. I mean, from a medical point of view, I mean, when we were brought up, you were said, make up your mind, do something. I mean, you'd be lined up when you were a student and or a young doctor and say, make up your mind, what are you going to do? You can't flip around, and that was put on, especially the surgical side, make up your mind. So you were brought up or you were chosen because you did that. And because you were chosen, I hate to say old boys network, but old boys or old girls network, but you were chosen because you made decisions, you carried them out. You were brought up in their likeness. So that probably, drove some of that. What do you think about the pushbacks that are now occurring to that Montgomery decision?
I think it's quite difficult to see it happening. I think you highlighted really well there, the really privileged position that medical practitioners are in, people, and I think it's hugely important that people trust their doctors. And I'm not saying for a minute that, everybody should be questioning absolutely everything that their doctor tells them, but I think what you've said really brings home, that doctors and clinicians they are very powerful in an interaction between a patient and their doctor or their nurse or their midwife, whoever it might be. And there is a power imbalance there. And I think that's why Montgomery was so powerful, because it really highlighted to medical practitioners that they have to be involving patients in their treatment decisions and actually telling them if they have alternative treatments, and not just sort of, as you say, make a decision and just start down a track that you can't stop. So to see pushback against that case is quite difficult because, as I say, it was a seismic change in how patients and doctors related to each other. Um, the case of McCulloch, which was a Scottish case that went to the Supreme Court, that's probably one of the biggest pushbacks and sort of limits on Montgomery. And it's all about whether a doctor has to still recommend an alternative treatment, which is one that they don't recommend. And it sort of moves us back towards Bolam as being the test and the standard. And I think for me, it's still quite difficult because my view is that, people need to be aware of the alternatives. They need to know what their options are, even if it's something that, perhaps a doctor doesn't recommend it because it's a treatment they can't offer in their hospital, but perhaps that treatment is available somewhere else and a transfer would be possible. So I think there's a lot of nuance as well in this area, and I think every case has to be judged on its own facts too, which, makes it more difficult to comment. But it is disappointing to see pushback on Montgomery because of everything it stood for and everything that it meant for patients and for pursuers in the law.
It was a landmark case. There's absolutely no doubt about it. Then the pushback comes, and it's to do with, what is reasonable in the circumstances, and what does a reasonable doctor do and say? For instance, an alternative, you might say, would be alternative medicine. Go and take this potion or that potion because somebody says that potion might work. And it cannot be that we decide that a doctor has to say, well, if you take, raspberries, that might help. And I really have to tell you about that. So there's something to do with reasonableness and what a reasonable medical practitioner would do, which leads me into the other concept that we discussed was therapeutic reassurance. That has been something. I mean, how much should a doctor say? One of the things we've always been brought up said, don't put people off having treatment by telling them, if you have a whiff of an anesthetic, you could die. So where does therapeutic reassurance come into this?
I think it's a good question. I suppose my take on it is that people need to be presented with all the options and they need to be given all of the information so that they can make an informed decision. And as you say, if there is a chance of having a general anesthetic that it will kill you, well, you need to know about that. But you also need to be told, well, if you don't have this surgery, there is a 20, 30, 50% chance, whatever it is, of, whatever symptom arising. And that's again where it gets into what does the individual patient want? What are their circumstances? Some people don't want to know about treatment and they don't want to be told all the options. And they just say, Doctor, I trust you. I want to, go with whatever you tell me. And that's addressed in the Montgomery decision. But I think you need to be assessing your patient and assessing, how much information do they want? Do they want to be told all of the options? And again, it all has to be tailored to the patient. And your example of the anesthetic, well, if they don't have this surgery, what will their quality of life be? What will their survival chance be? Is that a chance they're willing to take? Would they rather have a few good years with some discomfort and avoid the operation, or would they rather chance it? And I suppose everything is so, patient specific. And I think that's what the
It's
focus has to be
specific, I
on
think
is
that's the point.
what is the patient's own circumstances, their symptoms, and their need, instead of sort of applying a cookie cutter approach to, well, I like to do this procedure, so I will be doing it on every single patient. I think that's where the patient autonomy has to come in, and doctors have to be thinking about their in the patient that is in front of them, and all of that patient's needs, wants, hopes, and dreams for their future.
Well, we had that. I mean, when keyhole or laparoscopic surgery came in, I was one of the ones that brought it in. And, you know, older surgeons couldn't really stop their practice at that time and learn something new. So they would do the old form of gallbladder surgery and wouldn't tell them or say, well, that's what I do. And then when laparoscopic surgery came in and very rapidly took over, then what did they do? Did they continue their practice, stop their practice? What did they do? And that became a big issue for doctors at that time. So there is that. I think where we're coming from really at the end of the day is we have to write down the decision. If I decide not to tell you something, I need
Mhm.
to put it down in writing somewhere. There's no point 5 years later when somebody's going through the notes saying, yeah, it doesn't say that in the notes. You know, needs to be written down. This is the reason I did that. And if you, as a doctor, have a reason for not saying that to someone, um, then that can be looked at by other reasonable practitioners. Say, well, actually, given the circumstances at that time, that was reasonable not to say that, or it was reasonable not to. I mean, they were so upset psychologically that it would not be a reasonable thing to do, or to stop an emergency operation because you had to go through all this list and all that sort of thing. So there are also, I mean, what do you do during surgery when you see something else? But you've got to document it, and I think that's important so that people can be transparent and look at it later. And that's another thing about transparency afterwards, to talk to your patient, to talk to relatives transparently. Um, we talk about the duty of candor and saying, I'm sorry.
Mhm.
Unfortunately, that becomes saying, I'm sorry for everything in sight. And it may be, I'm sorry for your trouble, but I'm not saying I did anything wrong. But of course, if a client hears, I'm sorry, so says, so you did do something wrong, or you wouldn't have apologized. And I've seen several cases of that very recently where they said, well, the doctor said they were sorry, therefore they were wrong. And you're going, it's not quite what it means. So yeah, there's the therapeutic reassurance, and I totally agree with that. And I think most would, about patient autonomy. And we pointed out that if you do deviate from it, you've got to put a reasoning down. Like any guideline, they're guidelines, they're not rules. And you've got to, if you deviate from them, you can, but you've got to say why. And I think that's where we're all coming from.
Mhm.
So from your point of view, then, I mean, that's a consent issue, and I think well done to Balfour+Manson for bringing that out, and I think everybody accepts it. It's not something that you play around the edges. But then we get a lot of clients walking in over the door and saying I'm not happy with what happened to me, or I think I was negligently treated. And I think Again, we're talking about maybe 60% plus of people walking in of the door don't have, for any reason, a valid claim. So how do you approach, your onboarding and people coming in to decide whether or not you're going to make your client into a plaintiff?
Well, first of all, I think what you were saying about apologies and the duty of candor, I think that's really interesting because my experience of speaking to people who are thinking about bringing claims or interested or just want more information about the process, the majority of them do say if someone had just explained what happened to me and apologized and actually meant it instead of it just being, sorry this happened, then they probably wouldn't have gone down the line of making a claim. But I find a lot of people feel aggrieved at how they've been treated. They don't understand what's happened to them. For a lot of our clients, going through the process of investigating a medical negligence claim is the first time that someone's actually sat down and explained what happened to them. And to me, that's just incredible. This is, it's people's physical bodily autonomy that's being affected, and they don't even know what's happened to them and why they're having the problems that they're having now. So that's slightly off topic, but I just thought when you
No,
mentioned
that's great.
apologies,
I think
it's
that's
really
very reasonable.
interesting.
So a lot of what comes out of that is communication skills,
Mhm.
those soft skills of
Yes.
communication.
Mhm.
And they are rushed. I mean, you take GPs at the moment, they're supposed to see somebody every 10 minutes.
Mhm.
And there's more and more people in hospital. You know what the waiting lists are, your outpatients are cut down. And there isn't the time that we used to take with patients. And I do think that's been something that the government need to address about these targets and numbers and all that sort of thing. And they're people we're talking about. And
Mhm.
you're absolutely right. People need to communicate with and need to take that time for communication, not just perfunctory go back. So 100%. So how do you then set about assessing people come in over your front door?
Well, it's a really important part of our process, and I think it's something that we take very seriously. And I think we probably do spend quite a lot of time going through things with people when they first approach our firm. We try and get as much information as we possibly can from them. We try and work out whether they have lodged a complaint with the health board or the GP or whichever kind of medical practitioner it is that they are, concerned about. We try and find out if they've lodged a complaint, if they've had any response to that, if there has been perhaps a significant adverse event review report that they've received, because these are, I'm not sure how it works down south, but certainly up in Scotland, they can be triggered by the health board itself. So sometimes the first that people are aware that something's gone wrong with their care is that they receive an SAER report or they're notified that an SAER is underway. So that's really important information for us. So what we tend to do is we'll speak on the phone or over Zoom, something like that. We'll maybe do a face-to-face meeting if the person prefers that. And we just go through everything in chronological order and just glean exactly what's happened. Um, we ask them where they think the negligence might be, and I know that's a difficult legal question that we need expert input and things like that, but people tend to have quite a good sense of where their care has fallen down. So we'll ask them that, and then we'll also ask, what is the outcome and what injuries have you actually suffered? Because a lot of the people who contact us, they can be very distressed and they're contemplating all sorts of awful things that could have happened to them as a result of poor care. But we always, and it makes us sound quite ghoulish, but we need you to have actually been injured for a claim to succeed. And that can be quite difficult sometimes for people to understand because they feel so passionately and so strongly about them. They've received the wrong care and the ramifications could have been huge, but we need to see that they've actually been injured. So we do take the screening process quite seriously. And I think, there's different reasons for that. Obviously, business reasons for not taking on cases that aren't necessarily going to go anywhere, but also really importantly, almost from a professional, moral, ethical feeling towards people who've gone through something really awful, to not then put them through, what could be years potentially of a medical negligence claim that we at the outset don't feel would have prospects of succeeding. So it's a really important process, and I think it's something I'd say to any firm, any solicitor, that, your triage process has to be really good, and you have to really take your time and really consider what's coming over the doorstep, and what you think is a good claim, and really
That
only take
intake,
forward.
I think what you're coming there, that intake is valuable. Do you have a specific intake questionnaire, or how do you get, I mean, because a lot of times this is delegated to staff coming in as opposed to the experienced solicitors. So how do you ensure that they get a good, do you have a questionnaire? I mean, what do you do for intake? Do you have an intake form?
So I know some firms operate slightly differently to us. So we don't just send something out to a potential client and just say, fill this in, tell us what happened. We value a much more personal approach.
Yeah.
And I think it's really important to give people that time at the outset. And it builds a really good relationship. So if you end up taking somebody on, within quite a short space of time, they're going to be speaking to a solicitor. So our initial screening is done by a non-solicitor, but someone who is very experienced at dealing with these kind of cases. And then she does fill out a questionnaire, which just has sort of the key points that we need to get, but
But you
obviously
have those
it
key
can
points. You're not just having a conversation and saying,
exactly.
oh, well, that looks all right. You
Mhm.
have some key things that you're looking for.
Mhm.
And, if that ticks the box, then it goes on. Is that where we're coming from here?
Yeah, essentially. And I think having that kind of the set questions that we do go through, it's quite helpful sometimes if you've got a caller who is quite distressed or someone who's quite upset, and talking through everything can be quite difficult for them. So if you just pull it all right back to the basics and say, well, which hospital did you go to? When did this happen? Instead of just saying, oh, tell me everything, because if you've done all your legal training and you've learned how to examine and cross-examine witnesses, open questions are not always the most helpful. So we ask quite specific, focused questions to get the information that we need. And, as we've kind of touched on, what can be very important to people about their case and about the care they've received isn't always necessarily the most important to whether they've got a good medical negligence claim. So how they feel about how they were treated and things like that, it's not really what we need to focus on. Obviously, we don't rush people through talking about that because it is very important, and being heard is very important to um, pursuers in our line of work. But we don't really focus on, if someone felt aggrieved at how a nurse spoke to them or something like that. We tend to focus more on the kind of the meat on the bones rather than, the superfluous details, if that makes sense.
And sometimes I've spoken to others that say that one question I have at the end is, what exactly do you want from this?
Yeah, it's a
So
really
they say, I
useful
want an
question.
apology, or I want to understand what happened. And, you know, you may suggest, well, make a complaint, do something else first and see if that satisfies what you need. So there are gradations of taking the thing on to go before going full out. I think that's where you're coming from. And you did point out a very important thing too. It is a business. Like it or lump it, it is a business. And I know you guys do no win, no fee.
Mhm.
And if you took on everything that walks in, if you were totally sympathetic and empathetic to everything, that would not do well for your firm, never mind for the client, and also for the medical and nursing staff on the other side. There's a balance there somewhere. If a case is not strong, of not going in, or yeah, maybe a communication deficit somewhere, but it's not a case. But if it's going to drag on for 5 years, the other side of that is the practitioners on the other side of that have to live with it for 5 years, hanging over their head and their practice. And that, there's both, expectation. So I think what you're saying is very reasonable and very, very down the middle there, which I think it just shows the experience that you have. And, the way you guys are thinking about this, which is most impressive, that you understand not just to take on something for the sake of taking it on. You'll help those people who have a decent case, and you'll shut down ones that aren't, or are de minimis and really aren't going far, because they psychologically get harmed by it, but so does the other side. And I
Mhm.
mean, in some of the cases in obstetrics, I mean, when it's really taken, a lot of midwives never work. And that's awful when you've trained all your life to be that. And then this happens to you and you feel mortified and you just can't bring yourself to do it again. So
Mhm.
there's that balance. And I just hear from you that as a firm, you do that balance. So I think that's been absolutely fascinating today. We've covered a lot of stuff, didn't we? We covered Montgomery and the pushback on it, and we talked about therapeutic reassurance and reasonableness and all those aspects. And we looked at your screening process, and I like that, where you have someone, but they have a structure to it. And it is about communication. Poor communication by medical staff leads to a lot of problems. And then it's the communication of yourself, having people listen to, which is what they're complaining another professional didn't do. And that you make sure that that is happening. And then we talked a wee bit about the business end. So I think there's been a lot of very, very good points for our audience here. And I really, really thank you so much for coming on today.
No, thank you for having me. It's been really interesting to go through everything. Thank you.